I had a question from an unmarried individual who's in a long-term relationship, and she was asking whether or not an estate plan is really that important since she's not married. And my answer to that is that it's probably more important. My name is Philip Bruce. I'm an estate planning attorney here in Minnesota, and there are some default rules out there about what happens to your stuff if you don't have a will or some other document in place. These are called the intestacy statutes. An estate that doesn't have a will document is considered to be intestate, and these are the rules that are going to govern that situation. And if you're married, it doesn't get split up the way you probably think it does, but it does have some automatic rules. Your spouse gets a lot of stuff, the kids might get something, it all depends on your situation. None of that's gonna happen for an unmarried partner though. They're not gonna be in your estate at all. And if that's what you want, good. Just make sure that the backup rules give it where you really think it's gonna go. They probably don't, but if you're comfortable with that, great. No will needed. You can also do beneficiary designations on your various accounts that give it to this other person. You could own the house jointly. There's some things to be very, very careful about if you are going to be a joint owner on a home with an unmarried person, or with an unmarried partner, but you can do it. So there are some substitutes you can do, but the default rules just don't contemplate this, and because of that, it's almost more important to have a will or irrevocable trust in place so that things will do what you want them to do and not what the default rules do, and you don't have to finagle all these things and make them kind of work. You can really get a robust plan that's going to do what you want to do. It gives you peace of mind of knowing your plan will be the one that we use. A will goes through probate. A revocable trust will avoid the probate process. Either way, either one controls where things are going to go, and when you don't have the default rules working in your favor, I would argue it becomes more important. And don't forget, we always have healthcare directives and powers of attorney. I need someone who can make healthcare decisions for me if I'm not able to make those decisions on my own, and I need somebody who can make my financial decisions for me if I can't make financial decisions on my own. That's the financial power of attorney. Most law firms who do estate planning do it as a package. Give that some thought. Any questions, give us a call here at Stone Arch Law Office. My name is Philip Bruce.